Hi guys, welcome to another episode of Attorney Vlogger, Law for the Everyday Layman. Today we'll take up part 7 on the law of obligations and we continue with the kinds of obligations. Specifically, we'll talk about obligations with a period. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? So what are obligations with a period? They are obligations whose demandability or extinguishment depends on the arrival of a period. Okay? And what is a period? It is a future and certain event which either suspends demandability or extinguishes an obligation. Okay? And how do we know what a day certain is? It is that which must necessarily come even if you do not know when. Okay? It must necessarily come. Because if the uncertainty is on whether or not that day will come, then that is not a period, it is a condition. Okay? So let's just distinguish period and condition. A period is future and certain, while a condition is future and uncertain. Okay? A period must necessarily come, even if you do not know when. It must necessarily come, but a condition may or may not happen. Okay? A period gives rise to the demandability or extinguishment of the obligation, but a condition may affect the very existence of a condition of an obligation. Okay? An obligation may not come to existence. Okay? If a condition is not complied with. Okay? So it may affect the very existence of the obligation. A period does not have retroactive effect, but a condition produces retroactive effects in case of obligations to give. In case of obligations to do or not to do, the courts will determine if there is retroactive effect. And in case of a period, if the period is purely potestative, relying solely on the will of the debtor, then the courts can simply fix the period. The obligation will still be valid, okay? But in the case of a condition that is purely potestative, which relies solely on the will of the debtor, then the obligation is void. Unless, of course, there is a pre-existing obligation. But as a general rule, it is void. Okay? If you want to learn more about conditions, please refer to my previous video on pure and conditional obligations. Okay? Now, speaking of that video, if you remember my discussion there, in case the debtor binds himself to pay when his means permit, that is not a condition, but is properly treated as a period. Why? Because again, what depends on the debtor's will is not whether or not he will pay, because he is already binding himself. He says, I will pay, subject to the words, when my means permit me to do so. Okay? So, what he really intends is to set a duration. Okay? And since the duration is vague or unclear, the remedy here is to ask the courts to fix a period. Okay? You do not go to court and sue for payment. Ha? You go to court and you ask the courts, please set the period. And then you have to follow that period set by the courts. Okay? And then, after that period has arrived and the debtor has not yet paid, the creditor must make a demand for payment. And in case of failure to pay on the part of the debtor, then you will now file a case to collect the payment. Okay? From this procedure, there is only one exception. If that is in the case that the whole process will be rendered inutile, no? Meaning useless, no? Because of circuitousness of proceedings, or if it would be useless to go through that proceedings, as in the case where the debtor has clearly manifested that he is not going to pay. Okay? So as soon as when his means permit, or as soon as possible, or as soon as he has money. Those are the analogous words, okay? And in case you see those words, that is not a condition, that is a period, okay? This is an example when a period is purely potestative, relying solely on the debtor's will, in which case it is valid. Okay, again, the remedy is ask the courts to fix a period. Okay, now we can talk about the suspensive and resolutory periods rather, sorry. If you, similar to my discussion on conditions, suspensive conditions merely suspend the demandability of the obligation. Okay? If you remember my discussion on conditions, what are suspended are demandability, performance, and the rights. Since the rights are also suspended, the obligation may not yet exist. Okay? And in case the condition doesn't happen, then the obligation does not come into existence. But here in the period, in case of a suspensive suspensive period, the obligation already exists. Okay, in an obligation subject to a suspensive period, the obligation exists. What is suspended is merely the demandability. Okay, meaning you can only enforce or make a demand upon the debtor when the period arrives, because this is a suspensive period. Okay. So in other words, in case of an obligation which is subject to a suspensive period, rights and obligations exist, only the demandability is suspended. And upon arrival of the period, then the obligation becomes demandable. Okay? As for resolutory periods, when an obligation is subject to a resolutory period, upon arrival of the period, then the obligation is now extinguished and the duty of mutual restitution now comes into play. The parties must return whatever they may have received by virtue of the obligation. Okay? Now, there is a rule in case of fortuitous events. Okay? In case an obligation is subject to a period and then a fortuitous event happens, what is the rule? Okay? As a general rule, the fortuitous event does not interrupt the running of the period. Okay? A fortuitous event will only relieve the parties from performance. Okay? They do not have to perform during the time of the fortuitous event. What's an example? The Victoria Mills case, no? In that case, no, let's say Y entered into an agreement with X to mill the sugar of X for 30 years, but because of the war and the period of liberation, they could not mill sugar for 6 years, no? Can X demand an additional 6 years after the lapse of 30 years to make it to make up for the period within which Y could not perform his obligation? The Supreme Court said no, okay? Because during the fortuitous event of war, Y could not perform his obligations, okay? And the party who is bound to perform is relieved from performance during the fortuitous event. And therefore, X cannot demand an additional period of 6 years to make up for the 6 years of the fortuitous event. Okay? Let's go to the next rule, no? So before the period happens in a real obligation to give, no? In case the debtor has made a payment before the arrival of the period, then that is a payment by mistake. Why? Because before arrival of a suspensive period, the obligation is not yet due and demandable. So it's a payment by mistake. And in that case, the debtor may recover what he has paid by mistake pursuant to the provisions on solutio indebiti. However, okay, the debtor is presumed to know of the period, okay, and he should know when the obligation is due and demandable. And it is his burden to prove that he was unaware of the period in order for him to be entitled to recover what he may have paid by mistake. Okay? Now, the law also says, in case of loss, improvement, or deterioration of the thing, then the rules of pure and conditional obligations will also apply. But let's just repeat them now for your sake, no? The rules on loss, improvement, and deterioration apply only to real obligations to give, and if in case the thing is a determinate thing, in case the obligation is subject to a suspensive period which has arrived, and the loss, improvement, or deterioration must have happened before the period arrives. Okay? So again, the rules are, if the thing is lost without the fault of the debtor, then the obligation is extinguished. Okay? We do not punish the debtor because he has no fault. But if the thing is lost due to the fault of the debtor, then the debtor will be liable for damages. Okay? What if the thing deteriorates without the fault of the debtor? Then the creditor bears the impairment. But if the thing deteriorates through the fault of the debtor, then the creditor may choose either rescission or specific performance, not both, just one of the two, with damages in either case. Okay? Now, if the thing is improved by its nature or through the passage of time, then this improvement will inure to the benefit of the creditor. But if the improvement is due to the expenses made by the debtor, then the debtor will have the rights of a usufructuary. To learn more about usufruct, please just watch my episode on the contract of usufruct. It's in my playlist on security and credit transactions. Okay? Now, in obligations with a period, the general rule is that that period is made for the benefit of both parties. Okay? Why both? Let's say the contract is a contract of loan, of money, no? So in a case of a contract of loan, which is subject to a period, let's say, of payment for 2 years, okay, which earns an interest of 6% per annum, then the period is presumed to be for the benefit of both the creditor and the debtor. Why for both? Because on the part of the debtor, the period of 2 years is for his benefit because he is given more time to save or to earn money in order to repay the loan. Okay? And for the creditor, the period is for his benefit because he stands to earn interest. Okay? So in that case, since the period is for the benefit of both parties, the creditor cannot be compelled to accept payment before the arrival of the period. Why? Because you will be denying him of his right to earn interest for the 2 years. And the debtor cannot be compelled to pay before arrival of the period because you will be depriving him of the time to save or earn money to repay the loan. Okay? However, that's only the general rule. It may be shown through other circumstances that the benefit of the period is only for one of the parties. Okay? Now, in case the period is for the benefit of the debtor only, what's an example? Let's say, contract of loan again. Pay within a period of 1 year without interest. That's clearly for the benefit of the debtor because the creditor is no longer earning interest, and there is nothing for him to earn, no? There's no benefit for him. So in case the period is for the benefit of the debtor, he cannot be compelled to pay before arrival of the period, but he can pay before the period arrives if he so wants. Okay? And if the period is for the benefit of the creditor, he cannot be compelled to accept payment, but he can demand payment at any time that he wants because the period is for the benefit of the creditor. Okay? Now, let's move to judicial periods versus conventional or contractual periods. No? Judicial periods are simply periods set by the courts. And conventional or contractual periods are those set by the parties. No? And in case of judicial periods, here is the general rule. As a general rule, courts they have no power to set periods for the parties. Why? Because the obligation is only between the parties. Okay? So courts should not meddle into the affairs of the parties unless their power is invoked. Okay? Now, again, general rule, courts cannot fix a period for the parties. However, there are exceptions. Okay? First, In case the obligation does not fix the period but can be inferred from the nature or circumstances of the obligation, no, that the parties had intended that the obligation be subject to a period, then the courts can set a period, provided the parties go to court and ask for it, no? For instance, X asks Y to build him a home because he just moved out of his parents' home. Then, if the obligation does not state a period, you can necessarily infer that a period was intended for construction of the home. Okay? Why? Because the creditor had just moved out of his parents' home and he needs a place to stay. Okay? So you can infer that a period was intended, and you can ask the courts to fix a period for performance. Okay? Second exception to the rule that courts cannot fix a period is what I have discussed earlier. In case the duration of the obligation depends on the debtor's will, as when he says, I will pay when my means permit me to do so, or as soon as possible, or as soon as I have money. Okay? So those are the examples. Okay? Now, in case the court has fixed a period for the parties upon their asking the court to do so, then that period is fixed. Okay? The parties can no longer change the period after the court has set said period. Okay? Okay, so finally, please just remember that an obligation subject to a suspensive period is not demandable before the lapse or arrival of the period. Okay? So it cannot be demanded yet until the period arrives. Okay? However, there is an exception. Okay? The debtor will lose the benefit of the period, whether the period is for the benefit of both the parties or for his benefit only. The debtor will lose the benefit of the period in the following cases. Okay? First, after the creation of the obligation or after the parties have agreed to enter into the obligation, the debtor becomes insolvent. Okay? The insolvency doesn't have to be judicially declared. The debtor just has to be insolvent. Okay? So in that case, the obligation will now become a pure one, which will be demandable at once. Because again, the debtor loses the benefit of the period. However, there is an instance where the debtor may retain the benefit of the period, and that is if he furnishes guarantees and or securities for the obligation. Okay? Guarantees or securities. Now, to learn more about the contract of guarantee, you can refer to my video on the matter. No, it's in the playlist on security and credit transactions. But just for the sake of expediency, guarantee is a contract whereby one person known as the guarantor binds himself to answer for the debt, default, or miscarriage of the principal debtor. In other words, he answers to pay if the debtor cannot pay, as contrasted from a surety who binds himself to pay when the debtor does not pay. Okay? For a deeper discussion, please just watch my video on the matter. Okay? Now, the second instance when the debtor loses the benefit of the period is when if the debtor has promised to give guarantees or sureties, no? And then he does not give those guarantees or sureties or securities, no? In that case, then the law is punishing the debtor for breaking his promise. No, he promised to give guarantees or other securities, and he fails to do so, no, or he does not do so. Okay. Third instance when the debtor loses the benefit of the period is when, through the acts of the debtor himself, no, he has impaired those guarantees or securities which he may have provided. Okay, and then those guarantees or securities are lost through a fortuitous event. Okay, or simply lost. No. To this case is accepted the situation where the debtor, after the loss of the guarantees or securities, gives other guarantees or securities which are equally satisfactory. In other words, he replaced those guarantees or securities which were lost. No? So in that case, if he gives substitutes, then the debtor will retain the benefit of the period. Okay? Next, The debtor will lose the benefit of the period in case he violates an undertaking which was the consideration of the creditor to agree to the period. In other words, let's say a contract of loan. The creditor would have allowed the loan only if it was payable within 5 days. But the debtor pleaded for 1 year. But the creditor wasn't convinced. No, I want 5 days. So the debtor offered to, let's say, repair the piano of the creditor in exchange for granting him a period of 1 year. And the creditor agreed, okay, I'll fix my piano and I'll give you 1 year. So in that case, if the debtor fails to or violates the undertaking to fix the piano, then he will lose the benefit of the period, and again, the obligation becomes pure and demandable at once. Finally, the debtor loses the benefit of the period when he attempts to abscond, okay, or run away or flee to a different country or wherever else to evade payment or fulfillment of the obligation to the creditor, okay? Obviously, the law is punishing the debtor for his evident bad faith for running away from his obligations, okay? So please just remember these things, no? Special importance to the impairment, no, by the debtor of the guarantees or securities which he has furnished. A few exam questions are on that matter, okay? So that's it for obligations with a period. I hope you may have picked up a thing or two, and I hope to see you for the next episode, okay? Bye!